Hello all, good evening. Welcome back to National IAS Academy. My name is Raj Shekhar, and dear friends, we shall start today's class. That shall be our fifth class in our new initiative, that is Focus Prelims 2023. So for all those who are attending our class for the first time, let me briefly tell you about our new initiative. It is called as Focus 300 because we shall be covering 300 most important topics which are highly relevant for the upcoming UPSC Civil Services examination. So if you're an aspirant looking to crack UPSC Prelims in the year 2023, then please do not miss this series. All right. So telling you about the details of this initiative, every day we shall be posting one video consisting of 10 topics, and this shall run for next 30 days. So by the end of the 30th day, you would have covered 300 most highly relevant topics for the upcoming prelims. Not just that, along with this, you shall be also learning 3000 plus facts which can definitely help you in elimination techniques. Alright, with that being said, let us start today's class. These are the important topics which we shall be covering today. So let us begin with the first topic, that is single-use plastics. What do you mean by single-use plastics? As the name itself suggests, these are those plastics which cannot be used more than once. What are the example for single-use plastics? You, me, we all know. We all use in our day-to-day lives. For example, straw to drink coconut water. Would you be using the straw given by or used by another person? No, right? Definitely not. And just imagine using an earbud used by someone else, right? It doesn't look good, right? So all these plastic-made products are used only once. Hence, they cannot be used and they have to be disposed. Since their thickness is very low, lesser than 40-30 microns, they cannot be recycled, and hence it becomes difficult for the government to regulate these plastics, and ultimately they take hundreds of years in the environment to disintegrate and to mix up with the other things, and hence they are very harmful for the environment. Understanding this, the government of India, what did it do? It banned the use of single-use plastics from 1st July 2022. Have all plastic forms been banned now? No, sirs. Only some forms of single-use plastics have been now banned. They are under the ban now. What about others? The rest of them are still under usage, but with some modifications or some exceptions. Alright, so first thing, from 1st of July 2022, few forms of single-use plastics have been banned in India. India ultimately kept up its promise made to the United Nations Environment Programme. Prime Minister Modi had promised the UNEP that in coming years, India would be completely phasing out the usage of single-use plastics. So what about other plastics? Few forms of plastics are still in existence, but the government has made sure that or has mandated that the thickness of such plastics should exceed 120 micron. All right. So with that thickness, it becomes easy to recycle or even disintegrate. So along with the examples of straw and earbuds, there are also a few other single-use plastics which you could definitely remember. First one is polythene bags, face masks, coffee cups, cling film, garbage bags, and bottles of shampoo, soap, and cosmetics. I'm sure all of you have definitely used in one or the other way all of these products. All right. So why was this necessary? See, an Australian non-profit company says that single-use plastics make up 31% of all plastic produced globally. Not just that, 98% of single-use plastics are derived from fossil fuels. First of all, fossil fuels themselves are not good for the environment, right? After that, above all, the products made out of fossil fuels, that is single-use plastics make up 98% of total single-use plastics. Then just imagine, it's like a super villain among villains, right? So understanding this and showing concerns towards regarding this, the usage of single-use plastics have been banned from 1st July 2022 effectively. This you should remember. All right. The ban has been under the ban has been ensured under this law, that is Plastic Waste Management rules, plastic waste management rules. All right, banned since 1st July 2022. Then monitored by who shall look into the matters related to the usage of single-use plastics, the fines, or upkeeping the mandate made by the central government. It is CPCB, that is Central Pollution Control Board at the center, and respective state pollution control boards at state levels. What is the penalty? Penalty might be fine of up to 2 lakh rupees or even imprisonment up to 3 years. So be careful whenever in future you are buying anything that is related to single use plastics, you may be fined. All right, so why there is a need to ban single use plastics? These are 9 major reasons. First one is definitely they are made from fossil fuels. Second one is they have got huge carbon footprint and they take hundreds of years to get mixed up with the environment or to disintegrate. So all these 3 reasons are actually pointing towards one particular topic, that is Paris Agreement, or the announcement or promises made by the government of India under the Paris Agreement. Then apart from these 3 reasons, they also have a tiny percent or only tiny percentage of single-use plastic is recycled. These plastics leach toxins into food and drink, and they cause hormone disruption and ultimately lead to cancers. They also pollute our oceans, they kill marine animals and birds, and ultimately they end up entering our food chain, ultimately causing human beings or affecting human beings. All right, let us go back to the next topic. It's about battery waste management. Battery waste management. Dear friends, in the year 2022, a bill was passed by Lok Sabha, which was about the recycling of waste batteries or battery waste management amendment bill. The bill was named Battery Waste Management Amendment. Please note down, bill. Which year? 2022. So what was the previous law with regard to battery waste management? It was Battery Waste Management Act, passed in the year 2002. 2002. So battery waste management rules were in existence since 2002. Now recent amendment bill has been passed. It covers all kinds of batteries, including industrial, automobile, portable, and electrical vehicle batteries. So there's a provision under this new bill which speaks about extended producer responsibility. What does this mean? It talks about the responsibility of a producer of a battery who has to collect the battery after the usage from the consumer and give it for recycling. If not possible, dispose it in a proper manner. So recycling and disposal of these batteries is the responsibility of the producer now, as per the extended producer responsibility provision under Battery Waste Management Amendment Bill 2022. All right. The bill also has another clause which seeks to establish a fund called Environmental Compensation Fund. Environmental Compensation Fund. And the amount collected under this fund can be used by the central government to set up recycling facilities across the country. All right. This was necessary because, as per the data, an average person, one person uses approximately 10 batteries per annum or per 1 year. Out of these, almost all batteries are recyclable, which means 99.9% of batteries are recyclable, which unfortunately at present is not happening. But the government hopes that with the introduction of this bill and with the introduction of these provisions and new rules, this can be ensured and achieved, because batteries have various chemicals which, when not disposed properly, will ultimately affect the environment. So There was a question related to batteries in the year 2009 asked by UPSC in prelims examination. It says, in a dry cell, that is battery, which of the following are used as electrolytes? You all know battery runs using electrolytes. Ammonium chloride and zinc chloride is the right answer, dear friends. Next, we have something about multi-state cooperative societies. Multi-state cooperative societies. Why? An act was passed in the year 2022, making few amendments with respect to the operation or regulation of multi-state cooperatives. If you all remember, state cooperatives are covered under state list of the 7th schedule of the Indian Constitution. They are covered under the state list of the Indian Constitution. So that's the reason multi-state cooperatives have received significant attention in recent times. What is the reason? These state cooperatives, whenever they are operating within a state boundary, it has no concern or respect because that is completely manageable or managed by respective state government. But when branches or when the staff of these cooperatives start operating outside the border in another state, then the issue actually arises and it leads to multi-state cooperative societies situation. That's the reason to manage concerns regarding these cooperatives, the act has been passed in 2022. If you all remember, a new ministry was created in the year 2021. In 2021, Ministry of Cooperation was created. And who was the first Minister of Cooperation? In 2021, Ministry of Cooperation was created, and was the first person to be appointed as the Minister of Cooperation. It's none other than Honorable Present Home Minister Amit Shah. Amit Shah was the first Minister of Cooperation appointed for this ministry in the year 2021. Then, which constitutional articles talk about these cooperatives? There are too many articles. First of all, in 2011, 97th Constitutional Amendment Act was passed and it introduced the word multi-state cooperatives. Multi-state cooperatives, and it brought in some changes with respect to Part 9B of the Indian Constitution and Part 3, which talks about fundamental rights of the Indian Constitution. Under Part 3, a new article, Article 19, Clause 1, Subclause 2 was included. Alright, also there is another article, Article 43B, under the Directive Principles of State Policy, which talk about cooperatives under the Indian Constitution. So these are the important provisions of the Indian Constitution which directly talk about the cooperative societies in India. So these are the main characteristics of multi-state cooperative society and the registration. So there is new scheme which is named as PM Mitra. So what is the full form? Mitra means Mega Integrated Textile Regions and Apparel. Mega Integrated Textile Regions and Apparel. Mega Integrated Textile Regions and Apparel. PM Mitra Yojana. So, under this scheme, the government intends to start famous PM Mitra parks in various states such as Karnataka, Tamil Nadu, Telangana state, Maharashtra, Gujarat, Madhya Pradesh and Uttar Pradesh. In all these states, under 700 crore rupees project, the central government intends to establish PM Mitra parks. So Mitra here stands for Mega Integrated Textile Regions and Apparel. So the objective is to boost the production of textiles in India and make it competitive enough to compete with extraordinary brands across the world. So this scheme is being implemented through a special purpose vehicle. The scheme is being implemented through a special purpose vehicle registered for this purpose. All right. So if you look at the apparel sector or textile sector, the apparel or textile sector, it constitutes 2% of the total GDP, 2% of the total GDP, and also provides 2% of employment for the people of India. And not just that, India is the sixth largest exporter. India is the sixth largest exporter of textiles or apparels in the world. All right. So that being said, let us move on to the next topic, which is about design linked incentive scheme, which was announced in the year 2021. So there can be a direct question indicating one of the statements given in the question about the start of this scheme, about the year of start of this scheme. The scheme was started in the year 2021. It is called as design linked incentive scheme. It talks about the semiconductor, the production of semiconductors in India, its usage, and all those legal or policy initiatives that are necessary to make India a land for production of semiconductor chips, which is used everywhere literally in today's world, starting from your mobile phones, your microphones, your TV, your digital boards, or even your laptops. So it becomes very much necessary, especially during the pandemic time. It was proven that depending on few countries, including China, would be disastrous in difficult situations for these semiconductor chips. Hence, the program is anticipated to offer businesses involved in the manufacturing of semiconductors and displays as well as design. This is an incentive package that is competitive on a global scale. All right. So what are the benefits given under this scheme? First one is there is fiscal support, that is product design incentive. There is reimbursement up to 50% of the eligible expenditure subject to a ceiling of rupees 15 crores, and then there is incentive of 6 to 4% of net sales turnover over 5 years subject to a ceiling of rupees 30 crore, and the tenure is for 5 years starting from 1/1/2022. There can be 100 domestic semiconductor design companies. Up to 100 domestic semiconductor design companies can be beneficiaries under this scheme. Then there is something about Anti-Defection Law. So it was introduced through the 52nd Amendment Act of 1985 to the Constitution of India, which introduced 10th schedule under the Indian Constitution, and it was also called as Anti-Defection Law. Until then, there was a famous saying which said Ayaram Gayaram. Ram or Babulal Ram was a famous Indian politician who used to jump from one party to another party in search of the ministry that he's willing to join. So that's the reason defection was a common phenomenon before the introduction of this Constitutional Amendment Act. But after the introduction of this Constitutional Amendment Act, under certain provisions or under certain circumstances, it is now illegal to join a party after being elected from the ticket given to him or her by another party, except for a few exceptions. So, if you look at the recent decisions taken with respect to the calculation or determination of cases relating to anti-defection law by the Speaker, Supreme Court has passed few rules which have to be paid heed to by the sitting Speaker of any assembly or house. So anti-defection law, it was inserted in 10th schedule of the Indian Constitution through 52nd Amendment, which was passed in 1985. It holds ground for disqualification of MPs under Article 102, Clause 2 and 192, 191 for MLAs. Article 102 is related to MPs and Article 191 is related to MLAs. So when can we say that a MLA or MP is defected? If the elected member gives up his membership or abstains from voting. Then if an independent member joins any party after being elected independently, then if a nominated member joins any party after 6 months duration, after 6 months of his election or being elected to the house, if he joins any particular party, he is said to be terminated from his membership. And exceptions would include for speaker or chairman, and when a party, two-third majority of a party agree to merge with another party, then such members cannot be defected under the anti-defection law. Ultimately, presiding officer, that is speaker or the chairman, decides on the question of disqualification. It is his discretionary power. However, this discretion was questioned various times by the MPs and MLAs, and in that regard, Supreme Court has passed various rules and regulations. Please keep this in mind. Right? So, what are the advantages of anti-defection law? It provides stability and ensures party discipline. What are the disadvantages? Members' freedom gets affected. All right. So, which Supreme Court case talks about this anti-defection law? G. Vishwanathan judgment talks about the anti-defection law. All right. Next, there is an article about powers of speakers. Under Article 93 of the Indian Constitution, Speaker and Deputy Speaker both are elected. So in India, the office of Speaker is a dynamic institution that actually responds to the demands and issues that Parliament really faces as it carries out its duties. So officially, the Speaker is the House, head of the House, maybe Assembly House or even the Parliament or Lok Sabha. So likewise, House Speaker and Deputy Speakers are there in Lok Sabha. Likewise, Rajya Sabha has got Chairman and Deputy Chairman. And in this case, Chairman would be Vice President of India. Vice President would be the Chairman of ex de facto Chairman of Rajya Sabha. Alright. So these are the important powers of Speaker with respect to the suspension of MPs. This was continuously in news from past 1 year. And you can refer to these articles, that is these rules and articles, Rule 373 and 374 of Procedure and Conduct of Business, and also Rule 374A. 373, 374 and 374A in rule book talk about the suspension of MPs and the role and powers of speakers with respect to the provisions of suspension of MPs. The Speaker of the Lok Sabha derives his powers and duties from three sources. It can be a potential question. The question can be, the Speaker of the Lok Sabha derives his powers and duties from which of the following sources? If the option consists of these three points, that is the Constitution of India, the rules of procedure and conduct of business of Lok Sabha, and parliamentary conventions, that is residuary powers that are unwritten or unspecified in the rules, then please mark all of the above. Alright, then there was news about Punchi Commission. Please remember, Punchi Commission was constituted in the year April 2007 by the central government. It was presided over by Madan Mohan Punchi, who was a former Chief Justice of India, and it submitted its 7-volume report in March 2010. And the commission actually investigated and reviewed the operation of current agreements between the union and state, as well as a number of court decisions pertaining to the rights, obligations and duties in every area, including legislative relations, administrative relations, the function of governors, emergency provisions and other areas. So there was a news on Supreme Court ruling on the usage of discretionary powers by the governor. The Supreme Court time and again has made it clear that the governor has to act on the aid and advice of Council of Ministers under the Constitution of India. Few court cases which are relevant in this regard include the 1974 Shamsher Singh judgment, Shamsher Singh judgment, and then the 1969 Mahabir Prasad case. All right. So Article 175 Clause 2, Article 163 and Article 164 of the Indian Constitution talk about the powers given to a governor with respect to with respect to summoning the members of the house, or with respect to calling for a floor test, that is test of majority, right? So please note down these articles and make sure that you revise. I expect at least one question from this particular area. All right, so that was it for today. Thank you so much for joining. Please make sure to hit the like button and subscribe to our channel, and don't forget to share this video with your friends. See you in the next video. Take care. Bye bye. Good night.